person. So I'd like to say a little bit about the Litigant in Person project. Litigants in Person are also known as self-represented litigants. The background to our project is that it's funded by the Ministry of Justice at Greater Manchester Law Centre. It's a partnership with Citizens Advice North Lancashire, where I work with Ross Simmons. So the project has a very wide geographical catchment area. It's a new project. It's not replacing an employment advice project that existed in the past. So being a litigant in person can be an isolating experience, particularly with employment disputes, where the parties may have had a close relationship. This can add to the difficulty of managing the case, particularly without the assistance of lawyers or other third parties. The benefit of independent advice should not be underestimated. This may be because the dispute is legally complex, may also be because of the importance of the issues at stake to the litigant in person. Their sense of self-worth may be bound up with a job that they may have lost. So there's often an emotional dimension to the dispute, and it can be very stressful, particularly because of the uncertainty about, for example, paying their bills. So other problems can be triggered by the legal problem. For example, there may be pressure on relationships and economic pressure, and homes may be at risk. So are there many litigants in person? Well, statistics from the 2019 up to the end of March 2020 show that number of claimants, that's litigants in person with an employment tribunal claim, they're known as claimants. In that year, 56% of claimants were represented by lawyers. That's a decrease from 64% the previous year. Claimants were represented by trade unions in respect of 6%. That's an increase of 4% from the previous year. And no representation information was provided in respect of 32% of claimants. That's 33,000 claimants. And that's a 21% increase from the previous year. So year on year, there has been an increase in litigants in person, not only in the Employment Tribunal, but across all of the courts. Now, what might have led to this? Well, some believe that the withdrawal of legal aid from the majority of civil matters by a piece of legislation known as it was the Legal Aid Sentencing and Punishment of Offenders Act 2012, most commonly known as LASBO, has led to this increase. And this was predicted at the time that this was introduced, because at that time, for example, in employment cases, they were no longer eligible for legal help. The increase in litigants in person was predicted at that time. But in the years following, the Legal Aid Agency have saved hundreds of millions of pounds from their budget. And some would say that there has essentially been a cost transference to other government agencies. Also, early legal advice, we believe, is absolutely key, as it can stop problems escalating. And if they do escalate, we can be better informed as to what to focus on. So what are we going to cover this morning? Well, we're going to cover the Employment Tribunal, speak a little bit about the background of the tribunal and its role. We're going to deal with time limits, an organization called ACAS, and the mandatory early conciliation process, and pursuing a claim and what to expect. And what I'd like to do is go through the journey a client would take following a dismissal up to an employment tribunal hearing. It's important to bear in mind that ideally, if there is a workplace issue, the party should seek to resolve it internally through informal discussion, or failing that, through a grievance or disciplinary procedure. And this should be explored before filing a tribunal claim. Now, the system, the Employment Tribunal system and employment law, has got potential sanctions and penalties for failing to consider other options before you take your claim. For example, there's the ACAS discipline and grievance procedure. And if an employer, for example, goes straight to dismissal without going through the procedure, and the employee wins, then compensation can be increased by up to 25%. By the same token, if an employee doesn't use a grievance procedure or doesn't appeal, but later wins, there is a risk that they may have their compensation reduced by up to 25%. So it's important to bear that in mind. So looking at the Employment Tribunal procedure, the Employment Tribunal, going to look at the background of the tribunal. I mean, it's part of the Combined Tribunal Service. It's administered by the Ministry of Justice. And what is now the Employment Tribunal has its origins in recommendations of the Donovan Commission back in the 1960s. And what they wanted to set up was a place whereby workers could have easily accessible, informal, speedy, and inexpensive justice. Now, who could disagree with that as a name? It later became many of you may know that it was previously known as the Industrial Tribunal, and the employment judges were, what are now employment judges, were previously Employment Tribunal chairmen. While it's called a tribunal, the vast majority of claims as a result of changes over the years are now dealt with by a judge alone. That includes unfair dismissal, although it's important to bear in mind that it is possible to make an application to have an unfair dismissal claim heard by a panel of 3, but you have to justify it on the basis of an industrial relations reason. The panel of 3 now is usually the preserve of discrimination claims. So the way the system works, you make an application to send it to the central office in Leicester, and claims are allocated to a region. And that depends on where you physically worked. But just going back a couple of years, I think it's important to put in context the situation that currently exists in relation to a backlog. It's free to make an application to the Employment Tribunal. There are no fees. However, from 2013 until July 2017, fees were introduced and existed in the Employment Tribunal. And if you had a claim like unfair dismissal that went to a hearing, the fee you would have paid is £1,200. This was part of the age of austerity, in which the plan was that the courts would be paying their way, or they would generate more income. However, in July 2017, as a result of a case brought by Unite the Union, the Supreme Court ruled that those claims were unlawful. Sorry, those fees were unlawful. It didn't rule that fees per se were unlawful, but the fee structure as existed at that time was unlawful. So during this time, from 2013 to 2017, there was a 70% reduction in claims to the Employment Tribunal. As a result, the cost of running the tribunal went down. The number of judges working in the Employment Tribunal was reduced. The number of admin staff was reduced. And then in July 2017, fees were outlawed and the number of claims rocketed, with the result that the structure was not in place to deal with the surge in claims. This led to a backlog, and the pandemic, the COVID pandemic, has led to an increase in that backlog. Now, I think it's important to bear this in mind, because if you're pursuing a claim in the Employment Tribunal and you're wondering why it's taking so long, and perhaps why your correspondence isn't being answered in as timely a fashion as you would like, or why the telephone perhaps takes longer to answer, this is the background to that. And I think the staff in the Employment Tribunal are under considerable pressure and it's worth bearing that in mind. So just to give you some details about claims presented at the Employment Tribunal, during 2019 to 20, the Tribunal accepted a total of almost 104, just below 104,000 claims. That was down from 121,000 the previous year. Now, how long is a claim likely to take? Very important question. Well, the answer, unfortunately, is a lawyerly answer, which is it depends. If you've got a straightforward claim, like an unpaid wages or notice pay claim, that's likely to be heard reasonably quickly. If you have a complicated, for example, discrimination claim with a number of witnesses that may go on for a couple of days, that's likely to take longer. Like the more complicated and the longer it will take, then the longer the wait. So in a recent parliamentary answer in relation to how long, what's the average time from filing a claim to a first hearing, from the 1st of April 2020 to 31st of March 2021. For single claims, that would be an individual taking a claim, 335 days. For those of you who like your figures in weeks, that's 48 weeks. And for multiple claims, like for example, equal pay claims, it's 388 days. That's 55 weeks. But many cases, the more straightforward can take considerably less. So it's important to bear that in mind. Oops. So time limits. If you're taking a claim to the tribunal, time limits are very important. So what is the time limit? Well, the time limit is 3 months less 1 day from the date of the event that you're complaining about. So if, for example, you're dismissed for gross misconduct, sorry, I'm not saying you. If, for example, a claimant is dismissed for gross misconduct on the 24th of January, the time limit is 3 months less 1 day to start early conciliation through ACAS. So 24th of January, go forward 3 months. That's the 24th of April, go back 1 day to 23rd of April, 2021. So that's the latest date by which you have to start early conciliation through ACAS. If you miss the time limit, when you start early conciliation, the time limit is paused, and the time spent on early conciliation, which can be up to 6 weeks, is added on to the time limit. But you should have at least 1 month from the end of early conciliation to decide whether you're going to file a claim or not. Not all claims have to go through early conciliation, but the vast majority do. Some that you don't have to go through, for example, employers' contract disputes or applications for what's called interim relief. And some claims have got a 6-month time limit, for example, statutory redundancy pay and equal pay claims. It's important to bear in mind that the obligation, if you're filing a claim at the tribunal after going through early conciliation, it's important to bear in mind that the obligation is on you to file it, to get the claim there. It's not sufficient to put it in the post within the deadline or to send it electronically through the deadline. And the deadline expires on the last day before midnight. There have been some cases where claim has been received just after midnight. It's the case of Mr. Beasley in the National Coal Board, when it was received 1 minute and 22 seconds late, and his claim was rejected. His claim, Mr. Miller had a claim against Community Trust Limited. If you thought Mr. Beasley was unfortunate, well, in the Miller case, claim was submitted at a second before midnight and received 9 seconds after midnight, and that was rejected. So missing the employment, so what happens if you miss the Employment Tribunal deadline? Well, it's not absolutely fatal, but and the tribunal do have power to extend the time limit, and the tests are that it wasn't reasonably practicable. That's for unfair dismissal and money claims. There is a different test in relation to just and equitable. That applies in discrimination claims. My colleague Viv is going to give some examples in which some examples we've come across in the course of the project. So I'll just hand over to Viv.
Hi there. Yeah, so we get clients from all different stages during the process. Obviously, not every case goes all the way to tribunal. So I just have a couple of examples here of some of the types of things that we deal with. Obviously, the names have been changed. So we had Hamza's Employment Tribunal claim had been listed for 4 days in January 2022. It had already taken him a year to get to that point. His claim was concerning disability discrimination and race discrimination. Very late on in December 2021, it received a significantly increased offer for a settlement via ACAS on a draft COT 3. He contacted us to ask for help. He told us that he felt the issues in his case were very confusing. As he had no legal training, he was unemployed and could not afford a solicitor. And in any event, the timing of the offer during the holiday period had made it extremely difficult to find an alternative source of help. He felt under an immense pressure to make a dignified decision that he could be happy with. So what we did for him, we talked him through each clause in the COT 3 agreement, including advising him to go back and negotiate to include an agreed reference, which is really important. It costs the employer nothing, but very important for him moving forward and gaining future employment. So Hamza was able to agree to this settlement with confidence. He felt an immense relief to be able to move on and not to face the daunting prospect of a tribunal as a litigant in person. So that was a good result for him. Another example, we had, again, this shows you the role of ACAS, because of course, once you enter early conciliation, they're not there to give you legal advice, they need to act independently. So Adrian, this client, was referred to us by ACAS. He was dismissed for failing to hand a sick note in on time, in line with his employer's policies. He'd suffered a number of health conditions and he'd also become homeless after his dismissal. So he was able to gain support from us and also a charity called Humankind. They were successful in placing him in accommodation. As you can imagine, he felt very overwhelmed at the situation he found himself in. Regarding his employment, he didn't understand the legal process he was facing. So we were able to support him in understanding it and put together a calculation that he could take or he could put back to ACAS in their negotiations with his employer on his behalf. We explained what his rights were, should the negotiations be unsuccessful, and what the process would be should he wish to pursue it, and what the likely outcomes would be should he pursue it. And we just, in this way, we just helped him to navigate through a very difficult period in his life for a person who had no other recourse to legal help or financial means of support. I can't tell you the outcome because I'm afraid his negotiations are still ongoing. But yeah, that's just a flavour of the types of clients that come to ask for our help. I'll hand back to Michael.
Thanks very much, Viv. So looking at ACAS, who are ACAS? Well, it stands for ACAS, is the Advice, Conciliation and Arbitration Service. It's used by employers and employees. And there are two main ways of contacting them. You can do it on the telephone. You see there's a telephone number there. And you can do it online. It's mandatory for example, an unfair dismissal and all discrimination claims and all money claims to go through ACAS first. And it has been so since 2014. ACAS also...
Michael, sorry, can I just interrupt? It seems that your slide has gone down. I don't know if, there we go.
Right.
Brilliant.
Sorry. Right, sorry about... Hi. Okay, so can you see this slide? With an ACAS heading?
Yes, we can do, yes, that's great.
Sorry about that. Okay, so you see there that ACAS stands for the Advice, Conciliation and Arbitration Service. And there are two ways of starting early conciliation, both on the phone and online. And there's a separate, ACAS have a separate role in terms of having an advice line. And the purpose behind early conciliation is essentially to encourage settlement through conciliation and thereby keep claims out of the Employment Tribunal. The system's not designed to cater for claims going to a full hearing, and that's the same for all aspects of civil litigation. Early conciliation can also be started by the employer. So in 2019 to 2020, ACAS received over 135,000 individual notifications from employees and just over 3,000 from employers. In the same year, their national helpline answered over 780,000 calls. So it's a very useful source of advice. So what happens with ACAS? Well, what happens is that you'll be put in touch with a conciliation officer, also known as a conciliator, and they'll ask you some details about the dispute and what you want as a means of resolving the dispute. And they will go back and forth. They will then contact the employer if that's what you wish to happen. There's no obligation to engage in negotiations, but generally it's considered to be a good idea. So the conciliator will speak to you, and they really want to know what you want and why you want it. And they'll go to the employer and explain the position, your position. And the employer may come back with, well, I'm not interested, or, well, I'm not willing to pay that. However, I'm willing to consider paying some in this region, because money is usually the most common outcome. There can be reinstatement, there can be re-engagement. A reference can be part of a settlement, as we've mentioned earlier. There are occasions when you might not want to go through early conciliation. If, for example, you have started against one respondent. It's important to bear in mind that if you are thinking of taking a claim against more than one respondent, that's what the employer is called, or in a discrimination claim, for example, you might want to take a case against an individual, for example, the harasser. You have to start early conciliation against each of them. You have to have a separate early conciliation certificate for each. Sometimes in, for example, TUPE, transfer of undertaking protection of employment cases, it's a bit unclear as to who may be the respondent, the correct respondent. So you might wish to name two. You will need an individual certificate for both. So what happens if early conciliation is successful? Well, if it's successful, an agreement is drawn up by the conciliation officer, usually in a document called a COT3, COT3. The effect of that is that it will be legally binding on both sides. The sort of, So it'll be legally binding on both sides. What do these, sorry, can you hear me? Sorry. Sorry, was somebody want to make a comment there? No. So what happens if early conciliation is successful? Well, there'll be a document called a COT3, which is open to negotiation by both sides. And from a claimant's point of view, you have to, it's very important to ensure that you're happy with all of the terms of the agreement. Quite often there can be a focus on the money, and then a number of different terms get introduced. But it's important to ensure that you're clear about the sum of money, how much, also when are you going to get it? Because the payment of the sum of money in the fullness of time may not be particularly valuable. So you want a date as to when you'll get the money. As it's also very important to consider that a reference can be part of the agreement. If you succeed at an Employment Tribunal claim, the Employment Tribunal can't give you a reference. Sometimes employers want clauses such as non-derogatory clauses. There can be an agreement that you don't make any derogatory comments about your colleagues or your former employer. It can be a mutual agreement that they don't do the same. They don't make any derogatory comments about you. There are exceptions because what you're doing is you're settling your claims, and usually you're settling any other employment claims you may have that you're aware of at that time, with the exception of personal injury claims and employee pension claims. It's very common to have clauses on that say that there's no admission of liability on the part of the respondent. That's a phrase that seems to be covered in the news this morning quite a lot. There can quite often be a confidentiality clause that the terms of the settlement are confidential, and that usually there can be exceptions to that, such as family members. And if you want a particular person to be included as an exception, it's important to include that. And if there is a confidentiality clause, you have to tell them that they must keep it confidential as well. So what happens if early conciliation is not successful? Well, the ACAS officer, conciliator, will issue a certificate stating that you've participated in early conciliation. Now, the certificate is going to have a start date and an end date and a reference number. And to start a claim to the Employment Tribunal, you'll see in the claim form, there's a requirement to put in the reference number. So now the claimant has to decide whether they're going to pursue a claim at the Employment Tribunal, and they have to make sure that they do that within the time limit. It's also important to bear in mind that ACAS will still be involved if you file a claim at the tribunal, because they have always been involved in those claims, and ACAS try and get the same conciliator to be involved that was involved in early conciliation. So on the next slide, we've got an example of an early conciliation certificate. And that's the information that you need to put on the form. So I think you may have got a link to an Employment Tribunal claim form as part of signing up to the conference. I'm not sure if that's the case or not. There is a link. There is a link here. I don't know if you've got the capacity to go to look at the form at the same time, or whether it's relevant or not, but or whether you can do it later. But I'll just go through some of the information that's required and explain briefly why it's required. I mean, your own details are quite straightforward. However, it's important to bear in mind that if, for example, you move address, the tribunal corresponding with you by post, that you inform the tribunal. By the same token, if you change your phone number or if you change your email address, it's important to let the tribunal know. The respondent's details are very important because this is how the tribunal will correspond with them. But in addition to that, it's very important to identify the correct legal entity that you're taking a claim against. And that's partly why I mentioned that you can have more than one respondent if you're unclear or if you think that you need to take a claim against more than one. Because ultimately, the purpose of taking a claim is usually to recover money. And you want to ensure that you've got the right legal entity. And also you want to be able to know that, as far as you can, that if you succeed, that they'll be able to pay whatever award is made. Multiple claims, well, that's, for example, equal pay claims, for example. It's possible you could take a claim against somebody who hadn't employed you on the basis that you had been refused employment or treated less favorably in your application on the basis of a protected characteristic. Or you might have a victimization claim against a former employer. Earnings are quite important because essentially in many cases your compensation is going to be based on loss of earnings, particularly in an unfair dismissal claim, and you should include your benefits. Section 7, they ask you, have you got another job? The relevance of that is that if for example, you've got an unfair dismissal claim, there's a duty on you to mitigate your loss. Well, what does that mean? Well, it's just a term that means that you're expected to look for other work. You don't have to find other work, but you need to show evidence of looking for work, because quite often what the respondents will do is they'll say, well, we don't think that the claimant should have been out of work for 9 months. We believe that the nature of, for example, the job that he does, there are lots of vacancies in the area that he lives in, and quite often they produce ads or evidence of vacancies and ask, this is only if you win and you get to a remedy hearing, and they say, well, we've got these vacancies that we've identified. He doesn't appear to have applied for these vacancies. We think on that basis he hasn't done enough to mitigate his loss. And what a tribunal may do then is they might consider, well, they will consider the evidence, and they might conclude that had you made these applications, you might have found employment much earlier. Consequence of that is that the period of losses that they may award you would be reduced as a result. So it's very important to look for evidence, look for employment, keep a record of it, because claims are moving so slowly, you won't remember you may not remember what you were doing 6 months ago. I appreciate that if you apply for benefit, you'll be expected to keep a record and actively look for work as well. But it's very important to do that. Types and details of your claim. Well, that's the essential part, really. What is your claim about? Why do you think you have been unfairly dismissed? Why do you think you may have been treated less favorably on the grounds of protected characteristic? What do you want? Well, there are a number of boxes you can tick in terms of what you want, but the tribunal are obliged to consider reinstatement as a first remedy. However, statistically, it's very, very rare. Compensation is the most likely outcome, but there can be reinstatement, and if it's ordered and the employer refuses to reinstate, there can be additional compensation awarded. But reinstatement and re-engagement are very rare. If you've got a representative, well, they'll write to your representative rather than to you. All correspondence will go to the representative. That applies not only in the Employment Tribunal, but also in early conciliation. If you tell ACAS you've got a representative, they'll correspond with the representative. There's a question of disability. the rationale for that question is that if you have a disability that may have a negative impact or may make it more difficult for you to participate in pursuing your claim at the Employment Tribunal, the Tribunal has got an obligation to take that into account and to make adjustments to enable you to participate as fully as possible. There is a document called Equality. They are quite keen on ensuring that people with a disability can participate. And it's very important that that information is provided to them to enable them to make the arrangements necessary. Additional respondents, well, that's, as I mentioned earlier, you may have a claim against the harasser, or if you're not sure who your employer is, you may have more than one respondent. So I was going to suggest taking a short break, perhaps 5 minutes at this point, if that's okay. So I'll see you back here in about 48 minutes past. Sorry, about 46 minutes past. Okay, so I'll see you shortly. And when I come back, we'll deal with what happens once the Employment Tribunal claim is lodged. Okay. So what happened? Hi, welcome back. So what happens when you send your claim to the tribunal? Well, they will copy the claim and they will send a copy to the respondents together with their response form. And that's to be completed and returned within 28 days of when it's sent. The respondent completes the form, and the purpose of the form is to explain what their position is in relation to the various claims, because quite often, for example, an unfair dismissal claim will include claims perhaps for notes paid, perhaps for wages, perhaps for holidays. And when the ET3 is received by the tribunal, quite often an employment judge will do a sift and decide whether the claim should be allowed to proceed. Does the tribunal have jurisdiction? If, for example, there's a time limit issue, that will go to the jurisdiction of the tribunal. And they will also issue directions and consider whether a case management preliminary hearing is needed. And a copy of the claim will be sent by the tribunal to the claimant and to ACAS. And this will be the time when you get an idea, a clearer idea of the position the employer is taking. A copy of a response form, you may have seen it, but if you've got the copy, if you have access to a copy, then you can have a look at that. But essentially, the form has got a number of questions, and it asks the employer to confirm whether, for example, they agree that you've worked for the length of time you have, that the payments you've received are, that you say you are owed, are correct. And usually there's a lot more detail in relation to the reasons as to why they resist the claim. There's usually a document called the grounds of resistance, and that provides details. And essentially the case is going to be about resolving the factual disputes and interpreting the law in relation to each of the claims that has been made. Things about length of service, for example, are going to be very important, because, for example, in unfair dismissal claims, ordinary unfair dismissal claims, you're going to need 2 years continuous service. So what happens if they don't submit the form within the 28 days? Well, under the Employment Tribunal's Rule 21, an employment judge can issue judgment. That's if the information on the claim form allows a proper determination to be made. That would clearly be easier in cases where the dispute is about money. If there isn't, or if the judge thinks there isn't sufficient information, they can request that further information be provided. They can request that further information be provided. And if they make, or they can fix a hearing. Now, if the tribunal decide to issue a judgment, then the respondent can apply for a reconsideration of that. And the most common example, I think, is if the correspondence has gone astray, the respondent claims, well, I didn't know this claim had been filed because perhaps they've moved offices, or they've had problems with their posts, or it arrived after the deadline. They'll have 14 days to put in an application for reconsideration. And the tribunal will make, after they've received the ET3, they make case management orders. So what sort of case management orders are they likely to make? Well, the most common, the first one that's usually made is a schedule of loss. And this is designed to clarify what has happened since the end of employment. In other words, for example, has the claimant received, found other work? Have they received income from any other source? And it's designed to assist the parties in identifying the value of the claim, which should help negotiations. Often the problem can be that the schedule of loss is expected to be prepared fairly soon into the case, and things may change. So the schedule of loss is not set in stone, but it's the information that is available up to a particular point. It will need to be updated as circumstances change. And it's important that the losses are identified, any benefits that were available or you were receiving in your employment, that they are identified and claimed for. In addition, there will be case management orders in relation to disclosure, formerly known as discovery and information. This usually takes the form of the employer, for example, saying that they're a bit unclear as to the detail of the allegations. They may want some further information. In other words, when did things happen? Who was present? That sort of information. That works the other way as well, in that if the employee thinks, the claimant believes that there are documents that the respondent has that will assist them in their case, they can ask for them. If there's a dispute about whether they're material and relevant, an employment judge can make a decision about that. Once that has taken place, the theory is that the relevant and material documents are put in a bundle. Each is allocated a page number. And the purpose of this is to enable the parties and the tribunal ultimately to be able to follow a scenario and look at the relevant evidence to consider what decisions should be made in relation to the facts, and then the law should be applied to that. The witness statements are usually the final document that is required. And the purpose of the witness statement from a claimant's point of view, it's your opportunity to explain what happened and why you think you should win your case in relation to each of the claims that you are bringing. And it's essential that the witness statement is focused on the claims you were bringing, and that there is a link in your statement to the bundle of documents, because they want everybody essentially reading from the same script. So you can refer into, for example, page 42 of the bundle if there is, for example, a letter that you believe is relevant, And this is a means of taking the tribunal through the relevant evidence, all of the you and the respondent can all follow it quite seamlessly. That's the theory. And finally, there will be the hearings. I mean, there are case management preliminary hearings, which are designed to get the parties to identify the issues and set out a timetable for things to be done. There are two types of case management preliminary hearings. There are open ones, which are most common, dealing with, the open ones are ones where the public can have access and where decisions are made about the case. A claim may be struck out, for example, at an open preliminary hearing, but not at a closed one. There are liability hearings. That's about who wins and who loses. If you win a claim, there's then usually a separate hearing to deal with what remedy you should get. In other words, what's the reward for winning? Usually most common is money, the payment of compensation. Tribunal can make a declaration that you've been, for example, discriminated against, you've been unfairly dismissed. They can order reinstatement. They can order re-engagement. And the tribunal, So there's often a lot of focus on costs. Respondents quite often send letters threatening costs against claimants on the basis that they believe they're likely to lose their case and the tribunal will award costs against them. It's often a tactic that's designed to put fear into a claimant, to make them adjust downwards what they're looking for. And it can be quite intimidating for many claimants, particularly when you consider what level sometimes these costs that are incurred by respondents. So, but the basic principle in the Employment Tribunal is that the loser doesn't have to pay the winner's costs. That's it. And there is quite a strict test that is applied to determine whether or not costs should be awarded. And it's whether or not a party. So costs can be awarded against a respondent and against a claimant. And the test is whether they've acted vexatiously, abusively, disruptively, or otherwise unreasonably in either bringing of the proceedings or some part of them, or the way that the proceedings or part of the proceedings have been conducted, or that the claim has no reasonable prospect of success, yet that should have been apparent, but they continued with the claim or with their response. So the cost means some or all of the legal or professional fees incurred by a party in connection with this tribunal case. And it's not only the legal and professional fees, but it can also include fees for witnesses in attending a hearing. While it's very rare for costs to be awarded, the incidence of the awards are on the increase. In the year 2019 to 2020, total award of costs in cases were 177 in total. Of those, 47 were awarded to the claimant and 130 made against respondents, and about 3 times that were made against claimants. Costs are not the only. What happens if you have no costs? Well, there is an alternative called a preparation time order. So, for example, in the case of a litigant in person who doesn't have legal costs, the same test would apply, and preparation time is for payment in respect of the amount of time that they've spent working on the case. Can include I mean, for a respondent representing themselves, it can include their time spending preparation made by an employer, by an employee, but it doesn't include compensation at the final, representation at the final hearing. So it's in preparation for the final hearing. So the amount of a preparation time order increases every year by £1. I mean, currently I think it's £41. So what the tribunal do is they hear evidence from, for example, the claimant as to how long it took them in preparation time. And they consider this in relation to how complex was the case, what's a reasonable amount of time that they might have taken, and they assess the number of hours and multiply that by the hourly rate. Now, lots of cases can settle before the hearing or at any time. Cases can even settle during a hearing. Quite often, the tribunal are amenable to applications for brief breaks during a hearing if the parties indicate that negotiations might lead to a settlement of a case. So settlements, as I explained earlier, can come through ACAS on a COT3. There can be private settlement agreements between the parties. In relation to private settlement agreements, I mean, there are specific statutory provisions in relation to settlement agreements and the circumstances in which they can be legally binding. Because in employment law, there's concept of not contracting out of your employment rights unless certain safeguards are complied with. And in relation to settlement agreements, or they used previously be known as compromise agreements, claimant will have to get independent legal advice on the terms and the effect of signing the agreement. Usually that advice is from a lawyer. It can be from the delegated union. Official unions can have employees doing that, but quite common. There's a clause in a settlement agreement where the employer is willing to pay for the claimant to get independent legal advice up to a limit. And the reason it's there is because it wouldn't be binding otherwise. Recoupment of benefit provisions. If, for example, you have an unfair dismissal claim and you're out of work for, say, 20 weeks, and you've been getting job seekers allowance for 20 weeks, if you win your case and the tribunal make an order of loss of earnings for that period, the recoupment provisions apply. So if, for example, you're getting £300 a week, you lost £300 a week earnings and you were getting £80 a week job seekers allowance, for that 20 weeks, the job seekers allowance will have to be repaid out of the award and you get the rest. But if you settle, you get all of what you settle for. So that's an inbuilt incentive. Sometimes the parties decide to sort of split the difference between split the recoupment part, and it sometimes can encourage settlement in that the employer doesn't have to pay the DWP and the employee doesn't have to, the employee gets half of that. It can be a feature in negotiations or a factor in negotiations. There is a public register of employment tribunal decisions. So if your claim goes to a hearing and there is a decision, it will be on the register of employment tribunal decisions. It's operated by the government. It's publicly accessible. And yeah, it's been there, I think, since February 2017. So what if you're not paid your employment tribunal award? Well, unfortunately, it's not uncommon for awards to be either unpaid or only paid in part. The whole purpose usually is to recover a payment. Sometimes employers become insolvent, but the Employment Tribunal have got no role in ensuring that you get paid the award that they make. And it's important, I think, to always bear in mind in the course of the case whether your employment is likely to be able to make a payment to you. So if you're not paid in there, they potentially have the wherewithal to pay you. There are a number of ways you can do, but I think the most what I would suggest you use is there's a fast track procedure that was put in place a number of years ago. Hi, sorry, can you hear me? Okay. Sorry, there's a fast track procedure that's operated by the fast track procedure applies in relation to not only an award by the Employment Tribunal, but also if, for example, you've negotiated a settlement through ACAS on a COT3 and you're unpaid, you can use this procedure. In addition to that, there is the government have introduced a penalty, a sort of penal system in which if you fill in a form, the effect is that they write to the employer and they threaten them with a fine, and that they will publicly, there will be a public register in which they will be on, showing that they haven't made a payment. They're sent a warning letter within 28, and to make the payment within 28 days, and they may have to pay a fine if they don't. But the problem with that is that the fine, if they're fined, goes to the government and not to the claimant. So the fast track procedure, there's going to be a link at the end of this, but the way it operates is that you fill in a form and the system has been put together as a result of an arrangement with High Court enforcement officers, and there is a payment of, I think it's £66. It's possible to apply for a fee waiver if you satisfy the means test. And you complete the form, you enclose a copy of the Employment Tribunal award or the COT3 agreement, and they allocate it to a High Court enforcement officer. And if the High Court enforcement officer visits the respondent and finds that there are no assets, they're no longer there, for example, then you don't have to pay for the aborted visit. It's definitely the most effective way of enforcing it, assuming the respondent has assets. The other way, well, what happens if there aren't any assets? Well, the government have got an insolvency service. Well, part of the Department of Business, Enterprise and Industrial Strategy, BAES, as it's known, there's an insolvency service part of that, and they operate under the National Insurance Fund. Essentially, if the employer is insolvent, and there's a technical definition of insolvent, if they're in administration or in liquidation, then they can make certain payments. There are caps on these payments. For example, in a redundancy payment or a basic award, it's capped at £544 gross. But in relation to arrears of pay, there's a cap of 8 weeks. In relation to notice pay, it's capped at the maximum of 12, and it's statutory notice rather than contractual notice. In relation to holiday pay, they can pay up to 6 weeks per holiday that's accrued over the previous 12 months. If you win your unfair dismissal claim, they can pay the basic award, subject to the caps that I've mentioned. And that's designed to deal with the problem that is ever growing of what happens to employees' rights when the employer is insolvent. I mean, that's pretty much as I was planning to say. On the next slide, we've got a number of useful links. And sorry, you'll see them there. We can, I mean, they are possibly the most useful. It's important to bear in mind, I suppose, that there is a limited legal aid scheme, legal help scheme for discrimination in employment. It's means tested, and there's a link there to that. I haven't got much else to say, but if anybody's got any queries, any questions, I'm happy to try and deal with them.
Okay, I'm going to stop the recording now. If anybody has any questions and they want to put on their camera and microphone, please do so. Alternatively, you can type it into the chat box.